Quito that, I quote, in accordance with Article 9 of the Vienna Convention on Diplomatic Relations, the government of the Republic of Ecuador had decided to declare Mrs. Raquel Serur Smeke, ambassador of the United Mexican States in Ecuador, persona non grata. End of quote. The respondent announced that this decision was motivated by certain public statements made the previous day by the President of Mexico regarding the presidential elections recently held in Ecuador. On the 5th of April 2024, the Mexican Ministry of Foreign Affairs issued a press release expressing regret about the decision to declare Ambassador Serur Smeke persona non grata, and announcing that the government of Mexico had decided to grant political asylum to Mr. Glas Espinel. The government of Mexico also announced in that press release that it intended to request safe conduct for Mr. Glas Espinel and demanded that Ecuador, I quote, respect Mexico's sovereignty, comply with its international obligations, and guarantee the inviolability of diplomatic missions, end of quote. In a press release issued later that day, the Ecuadorian Ministry of Foreign Affairs announced that Ecuador regarded the granting of diplomatic asylum to Mr. Glas Espinel as unlawful under the 1954 Convention on Diplomatic Asylum and the 1933 Convention on Political Asylum, and that it would not accord him safe conduct. The ministry further stated that, I quote, in strict compliance with the norms of the Vienna Convention, Ecuador will continue to provide protection to the premises of the Mexican Embassy in Quito, end of quote. At around 10 p.m. that same day, the 5th of April 2024, armed members of the Ecuadorian security forces entered the Mexican Embassy without the authorization of the head of mission. They restrained the deputy chief of mission and forcibly removed Mr. Glas Espinel from the premises. On the 6th of April 2024, the government of Mexico notified Ecuador by way of a note verbal of its decision to terminate the diplomatic and consular relations between the two states with immediate effect. In press releases over the course of that day, the Mexican foreign minister announced that Mexico's diplomatic personnel would leave Ecuador immediately, that the embassy would remain closed indefinitely, and that her government intended to resort to the International Court of Justice to denounce violations of international law by Ecuador. On the same day, the Minister for Foreign Affairs of Ecuador stated to the press, as later reflected in a press release, that the granting of diplomatic asylum to Mr. Glas Espinel by Mexico was unlawful, and that the decision of the President of Ecuador to authorize the forced entry into the premises of the Mexican Embassy was taken in the face of a real and imminent flight risk of Mr. Glas Espinel. Turning to the examination of the request, the court recalls that Mexico requests the indication of the following provisional measures pending a final decision in the present proceedings, and I quote, A, that the government of Ecuador refrain from acting against the inviolability of the premises of the mission and the private residences of Mexico's diplomatic agents, and that it take appropriate measures to protect and respect them as well as the property and archives therein, preventing any form of disturbance. B, that the government of Ecuador allow the Mexican government to clear its diplomatic premises and the private residences of its diplomatic agents. C, that the government of Ecuador ensure that no action is taken which might prejudice the rights of Mexico in respect of any decision which the court may render on the merits, and D, that the government of Ecuador refrain from any act or conduct likely to aggravate or widen the dispute of which the court is seized." End of quote. And I shall now continue reading the order in English.
The court further records that pursuant to Article 41, paragraph 1 of its statute, it has the power to indicate, if it considers that circumstances so require, any provisional measures which ought to be taken to preserve the respective rights of either party, pending a final decision in the case. The court may, in particular, exercise this power only if there is urgency, in the sense that there is a real and imminent risk that irreparable prejudice will be caused to the rights which are the subject of the judicial proceedings, or that the alleged disregard of such rights will entail irreparable consequences before the court gives its final decision. The court must therefore consider whether such a risk exists at this stage of the proceedings. The court notes that by a note verbal sent on April 9, 2024, the Ministry of Foreign Affairs of Ecuador informed the Ministry of Foreign Affairs of Mexico that, and I quote, "the respect and protection of the premises, property, and archive of the Mexican Embassy in Quito will be guaranteed in accordance with Article 45A of the Vienna Convention on Diplomatic Relations." End of quote. The court further notes that by a letter addressed to the court and dated April 19, 2024, the agent of Ecuador provided more detailed assurances. Finally, at a public hearing that took place on May 1, 2024, the agent of Ecuador provided the following assurances on behalf of his country. I quote, "In accordance with the Vienna Convention on Diplomatic Relations and other relevant rules of international law, Ecuador will, 1. Provide full protection and security to the premises, property, and archive of the diplomatic mission in Mexico in Quito, to prevent any form of intrusion against them. 2. Allow Mexico to clear the premises of its diplomatic mission and the private residences of its diplomatic agents. And 3. Refrain from any action that is likely to aggravate or widen the dispute of which the court is seized, and instead to pursue the peaceful settlement of disputes." End of quote. The court considered that the assurances given by the agent of Ecuador encompass the concerns expressed by Mexico in its request. They include, inter alia, commitments to provide full protection and security of the premises, property, and archives of the diplomatic mission of Mexico in Quito, as well as to allow the clearing of such mission and the private residences of Mexican diplomatic agents. In addition, the respondent clarified at the hearing that these assurances were intended to cover, I quote, "precisely the same grounds as Article 45A of the Vienna Convention," end of quote, and to extend to inviolability insofar as Article 45 so requires. The court reiterates that unilateral declarations can give rise to legal obligations. Interested states may take cognizance of unilateral declarations and place confidence in them, and are entitled to require that the obligation thus created be respected. The court further reiterates that, I quote, "once a state has made such a commitment concerning its conduct, its good faith in complying with that commitment is to be presumed." End of quote. These assurances are especially important through the period necessary for Mexico to empty the premises of its embassy in Quito, as well as the private residences of its diplomatic agents. The court is of view that the assurances by the agents of Ecuador on behalf of his government, which were given publicly before the court and were formulated in an unconditional manner, are binding and create legal obligations for the respondent. In light of all the foregoing, the court considered that there is at present no urgency, in the sense that there is no real and imminent risk of irreparable prejudice to the rights claimed by the applicant. The Court observes that the conditions for the indication of provisional measures identified in its jurisprudence are cumulative. Therefore, having found that one such condition has not been met, the Court is not required to examine whether the other conditions are satisfied. The Court concludes that the circumstances as they now present themselves to it are not such as to require the exercise of its power under Article 41 of the statute to indicate provisional measures. The Court nonetheless deems it necessary to emphasize the fundamental importance of the principle enshrined in the Vienna Convention on Diplomatic Relations. As the Court has previously noted, and I quote, "There is no more fundamental prerequisite for the conduct of relations between states than the inviolability of diplomatic envoys and embassies, so that throughout history, nations of all creeds and cultures have observed reciprocal obligations for that purpose. In particular, the institution of diplomacy, with its concomitant privileges and immunities, has withstood the test of centuries and proved to be an instrument essential for effective cooperation in the international community and for enabling states, irrespective of their differing constitutional and social systems, to achieve mutual understanding and to resolve their differences by peaceful means." End of quote. The Court next reaffirms that the decision given in the present proceeding in no way prejudges the question of the jurisdiction of the Court to deal with the merits of the case or any questions relating to the admissibility of the application or to the merits themselves. It leaves unaffected the right of the government of Mexico and Ecuador to submit arguments in respect of those questions. I shall now read out the operative part of the order. For these reasons, the Court unanimously finds that the circumstances as they now present themselves to the Court are not such as to require the exercise of its power under Article 41 of the statute to indicate provisional measures. I shall now call on the Registrar to read the operative part of the order in French.
Par ces motifs, la Cour, à l'unanimité, dit que les circonstances telles qu'elles se présentent actuellement à la Cour ne sont pas de nature à exiger l'exercice de son pouvoir d'indiquer des mesures conservatoires en vertu de l'article 41 du statut.
Judges Bandari, Nolte, Gomez-Robledo, Cleveland, and Uresco append declarations to the order of the Court. The text of the order is available from today in typescript. It will be available shortly on the Court's website. The printed text will be available in due course. As the Court has no further business before it today, I declare the sitting closed.